at the Supreme Court, Ms. Lucas and Ms. Carrillo had challenged their unlawful suspensions and the illegal investigation and report that led up to their suspensions, and they were successful in the Supreme Court. The investigative report and the suspensions were quashed. But Ms. Lucas and Ms. Carrillo also sought constitutional redress. They were not successful at the Supreme Court with seeking further redress under the Constitution. When they then appealed to the Court of Appeal seeking constitutional redress, and the Court of Appeal dismissed their appeal, and the appellants then appealed to the Caribbean Court of Justice. It must be understood that the Court of Appeal did not uphold the suspensions. The suspensions have been quashed. What the essence, the issues that were before the Caribbean Court of Justice was, in addition to them succeeding with quashing the investigative report and their suspensions, is whether they were entitled to additional relief under the Constitution, because they alleged that their right to work and right to protection of the law were in addition to the reliefs they sought, had been infringed. Now, the Caribbean Court of Justice, in a split decision, 3 ruling in favor of the government and 2 finding favor with Ms. Carrillo and Ms. Lucas's appeal, found that the appellants had not made out a case that their constitutional rights had been infringed, but they did not uphold any suspensions. They did not uphold any illegal investigation and investigative report. The minority decision of the Caribbean Court of Justice forcefully said that Ms. Lucas and Ms. Carrillo's fundamental rights to protection of the law were infringed. In fact, there is one of the judges who went so far, he said that their constitutional rights was seriously violated, and that in addition to an award of damages and a declaratory order, he would have ordered that the ministry apologize to these women for the unlawful manner in which the investigation, the unlawful and unfair manner in which the investigations were